Good day, everyone. I'm Quasia and would like to share with you guys one of the most notable shifts in recent decades has been the rising global awareness of environmental issues, with public concerns for the state of the environment reaching unprecedented levels. This growing consciousness is largely a consequence of globalization, which has fostered an increasingly interconnected world where environmental well-being is now inextricably linked to societal progress. Prior to the 1970s, there are only a limited number of multilateral agreements addressing environmental issues. In People United for Better Living in Calcutta and State of West Bengal, the court recognizing the imperative for development to proceed in a manner that is harmonious with environmental preservation. Nowadays, there are explosive growth of countless bilateral and multilateral environment agreements, and the most significant one is UN Framework Convention on Climate Change, where 197 parties ratified. The question of what constitutes international environmental law is addressed through the broader framework set out in Article 38 of the Statute of the International Court of Justice. Identify the sources of international law as including international convention, customary law, general principle of law, and subsidiary means of judicial evidence. Therefore, multilateral environmental agreements are legal instruments with binding effects on countries that have agreed to become parties to a particular agreement through ratification or accession. The relationship between international law and domestic law is typically explained in two main theories, dualism and monism. Dualism posits that international law and domestic law are distinct and separate legal systems, each operating independently of the other. According to this view, international law does not automatically have domestic legal effect. Its application within a domestic legal system is contingent upon national legislation, expressly authorizing its incorporation. This approach maintains that the two legal orders do not directly interact unless domestic law explicitly permits such integration. Given the various ways in which states incorporate international law, some scholars argue that the term pluralism better captures the complex interaction between international and domestic legal systems, recognizing the diversity of approach and the nuanced relationship between them. In contrast to dualism, monism views international and domestic law as a unified legal system, grounded in ethical or logical principles such as human rights. States where the Constitution prescribes that once ratified, an international agreement has the force of law within the state. Under the monist approach, international law automatically becomes part of the domestic law legal framework without the need for specific legislation, action, or formal incorporation procedures. As a result, international law is directly applicable in domestic courts, allowing judges to make decisions based on international norms in matters that fall under their jurisdiction. The disparities can be shown in the application of international treaties. By focusing on one specific monist state, the Republic of Korea, is evident that, like other monist systems, the country incorporates international treaties directly into domestic law upon ratification. Article 6, Sub 1 of the Constitution of the Republic of Korea establishes that the treaties which are duly concluded and promulgated in accordance with the Constitution and in conformity with generally recognized rules of international law shall possess the same legal effect as domestic law within the country. In simple words, there is no explanatory note or interpretation clause for this. So it means that the international treaties have the same effect as the domestic laws. Republic of Korea is an active participant in global climate change efforts, having joined the UNFCCC in 1993, ratified the Kyoto Protocol in 2002, and signed the Paris Agreement on 2016, demonstrating its commitment to international climate action. In 2021, the National Assembly of the Republic of Korea passes the Framework Act on carbon neutrality and green growth for coping with climate crisis, marking a significant step in the country's effort to address climate change. The Act outlines ambitious targets, including a commitment to reduce greenhouse gas emissions substantially by 2030 and achieve a carbon neutrality by 2050. Like India, Malaysia follows the dualism model of incorporating international law into domestic law, meaning that international treaties do not automatically become part of domestic law. Instead, the rules of international law can operate if they are deliberately incorporated through separate legislation enacted by Parliament. While Malaysia has ratified numerous international treaties, including those related to climate change, and has actively participated in global climate initiative, it differs from the Republic of Korea in that it has yet to implement specific domestic legislation to address climate change. Unlike the Constitution of the Republic of Korea, the Federal Constitution of Malaysia does not contain a provision explicitly stating that international law shall be considered part of the law of the land, nor does it stipulate that treaties automatically become domestic law. However, Article 74, read together with the Federalist, grants the Federal Parliament exclusive power to legislate on matters related to external affairs, including treaties, agreement, and convention. This provision allowed Parliament the authority to implement international treaties and make them operative within Malaysia's domestic legal system through specific legislation, thereby facilitating the incorporation of international obligation into national law as affirmed by the case of the government of the state of Kelantan and the government of the Federation of Malaya and Tunku Abdul Rahman, where the court stated that where the power is vested in executive or federal government. The process for ratifying treaties in the Republic of Korea is outlined in the Constitution under Article 61. Treaties must first be approved by the National Assembly, the country's legislature. Additionally, the Constitution requires the draft treaties be submitted to the State Council, which consists of the President and key advisor for assessment. Once this process is complete, Article 73 grants the President the power of final approval and ratification of treaties. It automatically binds domestically. As stated above, Malaysia requires implementing legislation to effectuate international law and treaties obligation. In respect to the power of the executive, Article 39 provides that it vested in the Yang di-Pertuan Agong and accessible by him or by the cabinet or any minister authorized by the cabinet. The Constitution enumerates that even though the government has ratified a treaty and the treaty binds the government under international law, it has no legal effect domestically unless the legislature passes a law to give legal effect to that treaty. To be noted that the classification does not concern states' liability in international law, but merely the way in which international legal obligations are carried out within the states. As the words by Gibb Van Erf, the question of how norms of public international law are received into domestic legal system is largely a matter of constitutional law. The incorporation of international law as a general legal concern refers to the process through which international agreement and treaties become integrated into the domestic law of a sovereign state. Treaties or international agreements must be incorporated. But what does incorporate mean? Mendes elaborates on the concept of incorporation, emphasizing that it refers to the process by which a treaty becomes a binding component of domestic law. Article 26 of the Vienna Convention on the Law of Treaties enshrines the principle of pacta sunt serenda, requiring states to perform treaties in good faith. However, it also allows states the discretion to determine how they fulfill their international obligation within their domestic legal system. This process can take various forms, including the incorporation of an entire treaty through primary legislation, as well as enactment of statute or regulation that, while not explicitly referencing the treaty, fulfill the state obligations derived from it. An exception to states' freedom in determining how to implement treaties arises when certain treaties explicitly require domestic legislative action, as some treaties or specific provisions within them may mandate that contracting parties enact internal implementing legislation to give effect to the treaty's obligation, such as Article 5 of Genocide Convention 1948. As an example of a monist system, the Republic of Korea incorporates international treaties domestic law as stipulated by Article 6 sub 1 of its constitution. However, in practice, the full domestic effect of international treaties, particularly in climate change treaties, remains somewhat unclear. Domestic courts often treat such treaty as merely establishing rights and obligations between states, rather than as binding on individuals within the country. However, it has been often argued that the certain domestic law violate the climate change treaties in domestic court. However, there has been no decision by the Supreme Court of the Constitutional Court that certain domestic law conflict with climate change treaties in domestic trials. As similar to other treaties, climate change treaties seems to have only been used as a reference for interpreting domestic law rather than having the same direct legal effect. In a recent ruling case, the Constitutional Court in Woodpecker and South Korea held that countries' current measures in Carbon Neutrality Act were inadequate to safeguard citizens' rights, declaring that they violated constitutional provision. However, the court just used as a reference and pointed that Korea had failed to meet its carbon reduction targets, much less its obligation under Paris Agreement and other treaties, but do not necessarily have immediate or direct domestic legal effect. However, according to monist principle had been shown in the government report in the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, mentioned that Convention has the same effect as domestic laws, and when conflicts arises, the lex posterior rule and the principle of precedent of special law should be applied. In Malaysia, the Federal Constitution is silent on the primacy of international law over domestic law or vice versa, leaving the potential for conflict between a statute and a rule of international law. In such cases, the general rule is that domestic statute take precedent. This principle was highlighted in the case of public prosecutor against Wah Aji, where the court affirmed that judge may apply the law as it expressed in statute without considering whether such law conflict with international law. This approach reflects the common law principle of the supremacy of an act of parliament, although there is a presumption that parliament does not intend to legislate in contravention of international law. In some instances, a statute may explicitly provide that international law take precedence, but in the absence of such provision, domestic law typically prevails in cases of conflict. Although national court in a state based on the principle of judicial independence may choose to disregard international law and make decisions that conflict with it, the state itself remains responsible on the international plane for any resulting breach. In comparison with Republic of Korea, with the target for commitment in the Paris Agreement has legal force, while Malaysia is only included in a policy or planning documents. Even though Malaysia has shown its commitment to mitigating climate change, there has not been a single case brought to court on this issue. Malaysia's major challenges for unable to commit Paris Agreement largely stem from carbon dioxide emission from fossil fuel combustion and cement production, where one of the reasons was limited recognition of environmental rights. By looking to the case of MBF Capital Berhad and Dato' Param Kumaraswamy, involved a defamation lawsuit against Dato', a Malaysian jurist appointed as the United Nations Special Rapporteur on the independence of judges and lawyers. Kumaraswamy claimed immunity from the suit under the Convention of the Privilege and Immunities of the United Nations, to which Malaysia is a party, and certifies issued by both UN Secretary General and the Malaysian Minister of Foreign Affairs from his immunity. However, the Malaysian court disregarded these certificates, treating them as mere opinions and not binding, instead deciding that immunity issues would be resolved at trial. The Court of Appeal upheld this decision, demonstrating Malaysia's dualist approach to international law. This case highlights that the challenges of reconciling domestic legal decisions with international obligation in a dualist legal system were shown in Malaysian court disregard international law. There is a pressing need to improve the consistent application of international law and environmental law within domestic legal system, particularly in monist countries. While courts in monist system countries have made effort to interpret and apply treaties in a manner consistent with their objective, gaps remain in the direct invocation of these treaties in judicial reasoning. Specifically, the court showed that there is a tension between their frequent reference in ruling and the denial of their direct implications. Hence, the need to narrow this gap, stressing the importance of aligning domestic courts' decisions more closely with international obligation. To achieve this, the calls for enhanced collaboration between legal academia, practitioners, and the scholars of both international and domestic law. This continued exchange of views and joint research is seen as essential for ensuring that domestic implementation of international treaties is consistent and coherent with international legal standards, thereby fostering greater alignment between international and domestic legal frameworks. In a dualist system, international law does not automatically become part of domestic law and requires specific legislation for its incorporation. In my point of view, while this approach maintains a clear distinction between international and domestic legal orders, it presents challenges in ensuring consistent and timely application of international obligation. For effective implementation, there must be a better coordination among three branches of government: the judiciary, executive, and the legislature, to ensure that international treaties are swiftly transformed into domestic law through enabling statutes. Furthermore, there is a need for a more consistent judicial approach toward international law. Rather than viewing it as foreign law, courts should recognize international law as an integral part of the domestic legal system, provided that it does not conflict with local statutes or public policy. Such steps would help harmonize domestic legal practices with international standards and strengthen the state's commitment to the global legal norms. In conclusion, both the monist and dualist system face challenges in applying international law within domestic framework. In Republic of Korea, international treaties are automatically incorporated by their direct application, particularly in areas like climate change law remain inconsistent. In Malaysia, treaties require enabling legislation, leading to delay and potential conflicts between domestic law and international obligation. To improve, Republic of Korea should adopt a more consistent judicial approach, while Malaysia needs better coordination among the executive, judiciary, and legislature to enable timely incorporation of treaties. Both systems must align domestic law more closely with international standards to achieve greater legal coherence. That's all from me. Thank you. This is all of my bibliography.